What is Property? An Inquiry into the Principle of Right and of Government, by Pierre-Joseph Proudhon. Second Memoir, Part 6. Property once acquired by occupation and labor, it naturally preserves itself, not only by the same means, but also by the refusal of the holder to abdicate. For from the very fact that it has risen to the height of a right, it is its nature to perpetuate itself and to last for an indefinite period. Rights, considered from an ideal point of view, are imperishable and eternal, and time, which affects only the contingent, can no more disturb them than it can injure God himself. It is astonishing that our author, in speaking of the ideal, time, and eternity, did not work into his sentence the divine wings of Plato, so fashionable today in philosophical works. With the exception of falsehood, I hate nonsense more than anything else in the world. Property once acquired, good if it is acquired, but, as it is not acquired, it cannot be preserved. Rights are eternal, yes, in the sight of God, like the archetypal ideas of the Platonists. But on the earth, rights exist only in the presence of a subject, an object, and a condition. Take away one of these three things, and rights no longer exist. Thus, individual possession ceases at the death of the subject, upon the destruction of the object, or in case of exchange or abandonment. Let us admit, however, with M. Proudhon, that property is an absolute and eternal right, which cannot be destroyed save by the deed and at the will of the proprietor. What are the consequences which immediately follow from this position? To show the justice and utility of prescription, M. Proudhon supposes the case of a bona fide possessor whom a proprietor, long since forgotten or even unknown, is attempting to eject from his possession. At the start, the error of the possessor was excusable, but not irreparable. Pursuing its course and growing old by degrees, it has so completely clothed itself in the colors of truth, it has spoken so loudly the language of right, it has involved so many confiding interests, that it fairly may be asked whether it would not cause greater confusion to go back to the reality than to sanction the fictions which it, an error without doubt, has sown on its way. Well, yes, it must be confessed without hesitation that the remedy would prove worse than the disease, and that its application would lead to the most outrageous injustice. How long since utility became a principle of law? When the Athenians, by the advice of Aristides, rejected a proposition eminently advantageous to the republic, but also utterly unjust, they showed finer moral perception and greater clearness of intellect than M. Troplong. Property is an eternal right, independent of time, indestructible except by the act and at the will of the proprietor. And here this right is taken from the proprietor, and on what ground? Good God, on the ground of absence! Is it not true that legists are governed by caprice in giving and taking away rights? When it pleases these gentlemen, idleness, unworthiness, or absence can invalidate a right, which, under quite similar circumstances, labor, residence, and virtue are inadequate to obtain. Do not be astonished that legists reject the absolute. Their good pleasure is law, and their disordered imaginations are the real cause of the evolutions in jurisprudence. If the nominal proprietor should plead ignorance, his claim would be none the more valid. Indeed, his ignorance might arise from inexcusable carelessness, etc. What? In order to legitimate dispossession through prescription, you suppose faults in the proprietor? You blame his absence, which may have been involuntary; his neglect, not knowing what caused it; his carelessness, a gratuitous supposition of your own. It is absurd. One very simple observation suffices to annihilate this theory. Society, which, they tell us, makes an exception in the interest of order in favor of the possessor as against the old proprietor, owes the latter an indemnity, since the privilege of prescription is nothing but expropriation for the sake of public utility. But here is something stronger. In society, a place cannot remain vacant with impunity. A new man arises in place of the old one who disappears or goes away. He brings here his existence, becomes entirely absorbed, and devotes himself to this post which he finds abandoned. Shall the deserter, then, dispute the honor of the victory with the soldier who fights with the sweat standing on his brow, and bears the burden of the day in behalf of a cause which he deems just? When the tongue of an advocate once gets in motion, who can tell where it will stop? M. Troplong admits and justifies usurpation in the case of absence of the proprietor, and on a mere presumption of his carelessness. But when the neglect is authenticated, when the abandonment is solemnly and voluntarily set forth in a contract in the presence of a magistrate, when the proprietor dares to say, I cease to labor, but I still claim a share of the product, then the absentee's right of property is protected. The usurpation of the possessor would be criminal. Farm rent is the reward of idleness. Where is, I do not say the consistency, but the honesty of this law? Prescription is a result of the civil law, a creation of the legislator. Why has not the legislator fixed the conditions differently? Why, instead of 20 and 30 years, is not a single year sufficient to prescribe? Why are not voluntary absence and confessed idleness as good grounds for dispossession as involuntary absence, ignorance, or apathy? But in vain should we ask M. Troplong, the philosopher, to tell us the ground of prescription. Concerning the code, M. Troplong does not reason. The interpreter, he says, must take things as they are, society as it exists, laws as they are made. That is the only sensible starting point. Well, then, write no more books. Cease to reproach your predecessors, who, like you, have aimed only at interpretation of the law, for having remained in the rear. Talk no more of philosophy and progress, for the lie sticks in your throat. M. Troplong denies the reality of the right of possession. He denies that possession has ever existed as a principle of society, and he quotes M. de Savigny, who holds precisely the opposite opinion, and whom he is content to leave unanswered. At one time, M. Troplong asserts that possession and property are contemporaneous, and that they exist at the same time, which implies that the right of property is based on the fact of possession, a conclusion which is evidently absurd. At another, he denies that possession had any historical existence prior to property, an assertion which is contradicted by the customs of many nations which cultivate the land without appropriating it, by the Roman law, which distinguished so clearly between possession and property, and by our code itself, which makes possession for 20 or 30 years the condition of property. Finally, M. Troplong goes so far as to maintain that the Roman maxim, nihil commun habet proprietas cum possessione, which contains so striking an allusion to the possession of the ager publicus, and which, sooner or later, will be again accepted without qualification, expresses in French law only a judicial axiom, a simple rule forbidding the union of an action possessoire with an action petitoire, an opinion as retrogressive as it is unphilosophical. In treating of actions possessoires, M. Troplong is so unfortunate or awkward that he mutilates economy through failure to grasp its meaning. Just as property, he writes, gave rise to the action for revendication, so possession, the jus possessionis, was the cause of possessory interdicts. There were two kinds of interdicts: the interdict recuperandi possessionis, and the interdict retenende possessionis, which correspond to our complainte en caisse de cessation et nouvelete. There is also a third, adipicende possessiones, of which the Roman law books speak in connection with the two others. But in reality this interdict is not possessory, for he who wishes to acquire possessions by this means does not possess, and has not possessed. And yet acquired possession is the condition of possessory interdicts. Why is not an action to acquire possession equally conceivable with an action to be reinstated in possession? When the Roman plebeians demanded a division of the conquered territory, when the proletaires of Lyons took for their motto, Vivre en travaillant ou mourir en combattant, to live working or die fighting, when the most enlightened of the modern economists claim for every man the right to labor and to live, they only proposed this interdict, adipicende possessiones, which embarrasses M. Troplong so seriously. And what is my object in pleading against property, if not to obtain possession? How is it that M. Troplong, the legist, the orator, the philosopher, does not see that logically this interdict must be admitted, since it is the necessary complement of the two others, and the three united form an indivisible trinity: to recover, to maintain, to acquire? To break this series is to create a blank, destroy the natural synthesis of things, and follow the example of the geometrician who tried to conceive of a solid with only two dimensions. But it is not astonishing that M. Troplong rejects the third class of actions possessoires, when we consider that he rejects possession itself. He is so completely controlled by his prejudices in this respect, that he is unconsciously led, not to unite that would be horrible in his eyes, but to identify the action possessoire with the action petitoire. This could be easily proved, were it not too tedious to plunge into the metaphysical obscurities. As an interpreter of the law, M. Troplong is no more successful than as a philosopher. One specimen of his skill in this direction, and I am done with him. Code of Civil Procedure, Article 23. Actions possessoires are only when commenced within the year of trouble by those who have held possession for at least a year by an irrevocable title. M. Troplong's comments. Ought we to maintain, as Duparc, Poullain, and Lanjuinais would have us, the rule spoliatus ante omnia restituendus, when an individual who is neither proprietor nor annual possessor is expelled by a third party who has no right to the estate? I think not. Article 23 of the Code is general. It absolutely requires that the plaintiff in actions possessoires shall have been in peaceable possession for a year at least. That is the invariable principle. It can in no case be modified. And why should it be set aside? The plaintiff had no seisin, he had no privileged possession, he had only a temporary occupancy, insufficient to warrant in his favor the presumption of property, which renders the annual possession so valuable. Well, this a facto occupancy he has lost, another is invested with it. Possession is in the hands of this newcomer. Now, is this not a case for the application of the principle in pari causa possesser potior habetur? Should not the actual possessor be preferred to the evicted possessor? Can he not meet the complaint of his adversary by saying to him, "Prove that you were an annual possessor before me, for you are the plaintiff. As far as I am concerned, it is not for me to tell you how I possess, nor how long I have possessed. Possedeo quia possedeo." I have no other reply, no other defense. When you have shown that your action is admissible, then we will see whether you are entitled to lift the veil which hides the origin of my possession. And this is what is honored with the name of jurisprudence and philosophy: the restoration of force. What? When I have molded matter by my labor, I quote M. Troplong, when I have deposited in it a portion of myself, M. Troplong, when I have recreated it by my industry and set upon it the seal of my intelligence, M. Troplong, on the ground that I have not possessed it for a year, a stranger may dispossess me, and the law offers me no protection. And if M. Troplong is my judge, M. Troplong will condemn me. And if I resist my adversary, if, for this bit of mud which I may call my field, and of which they wish to rob me, a war breaks out between the two competitors, the legislator will gravely wait until the stronger, having killed the other, has had possession for a year. No, no, M. Troplong, you do not understand the words of the law, for I prefer to call in question your intelligence rather than the justice of the legislator. You are mistaken in your application of the principle in pari causa possessor potior habetur. The actuality of possession here refers to him who possessed at the time when the difficulty arose, not to him who possesses at the time of the complaint. And when the code prohibits the reception of actions possessoires in cases where the possession is not of a year's duration, it simply means that if, before a year has elapsed, the holder relinquishes possession and ceases actually to occupy in propria persona, he cannot avail himself of an action possessoire against his successor. In a word, the code treats possession of less than a year as it ought to treat all possession, however long it has existed. That is, the condition of property ought to be, not merely seisin for a year, but perpetual seisin. I will not pursue this analysis farther. When an author bases 2 volumes of quibbles on foundations so uncertain, it may be boldly declared that his work, whatever the amount of learning displayed in it, is a mess of nonsense unworthy a critic's attention. At this point, sir, I seem to hear you reproaching me for this conceited dogmatism, this lawless arrogance which respects nothing, claims a monopoly of justice and good sense, and assumes to put in the pillory anyone who dares to maintain an opinion contrary to its own. This fault, they tell me, more odious than any other in an author, was too prominent a characteristic of my first memoir, and I should do well to correct it. It is important to the success of my defence that I should vindicate myself from this reproach, and since, while perceiving in myself other faults of a different character, I still adhere in this particular to my disputatious style, it is right that I should give my reasons for my conduct. I act, not from inclination, but from necessity. I say, then, that I treat my authors as I do for two reasons, a reason of right, and a reason of intention, both peremptory. 1. Reason of right. When I preach equality of fortunes, I do not advance an opinion more or less probable, a utopia more or less ingenious, an idea conceived within my brain by means of imagination only. I lay down an absolute truth, concerning which hesitation is impossible, modesty superfluous, and doubt ridiculous. But, do you ask, what assures me that that which I utter is true? What assures me, sir? The logical and metaphysical processes which I use, the correctness of which I have demonstrated by a priori reasoning, the fact that I possess an infallible method of investigation and verification with which my authors are unacquainted, and finally, the fact that for all matters relating to property and justice, I have found a formula which explains all legislative variations, and furnishes a key for all problems. Now, is there so much as a shadow of method in M. Toller, M. Troplong, and this swarm of insipid commentators, almost as devoid of reason and moral sense as the Code itself? Do you give the name of a method to an alphabetical, chronological, analogical, or merely nominal classification of subjects? Do you give the name of method to these lists of paragraphs gathered under an arbitrary head, these sophistical vagaries, this mass of contradictory quotations and opinions, this nauseous style, this spasmodic rhetoric, models of which are so common at the bar, though seldom found elsewhere? Do you take for philosophy this twaddle, this intolerable pettifoggery, adorned with a few scholastic trimmings? No, no. A writer who respects himself will never consent to enter the balance with these manipulators of law, misnamed jurists. And for my part, I object to a comparison. 2. Reason of intention. As far as I am permitted to divulge this secret, I am a conspirator in an immense revolution, terrible to charlatans and despots, to all exploiters of the poor and credulous, to all salaried idlers, dealers in political panaceas and parables, tyrants in a word of thought and of opinion. I labor to stir up the reason of individuals to insurrection against the reason of authorities. According to the laws of the society of which I am a member, all the evils which afflict humanity arise from faith in external teachings and submission to authority. And not to go outside of our own century, is it not true, for instance, that France is plundered, scoffed at, and tyrannized over because she speaks in masses and not by heads? The French people are penned up in 3 or 4 flocks, receiving their signal from a chief, responding to the voice of a leader, and thinking just as he says. A certain journal, it is said, has 50,000 subscribers. Assuming 6 readers to every subscriber, we have 300,000 sheep browsing and bleating at the same cratch. Apply this calculation to whole periodical press, and you find that, in our free and intelligent France, there are 2 millions of creatures receiving every morning from the journals spiritual pasturage. 2 millions! In other words, the entire nation allows a score of little fellows to lead it by the nose. By no means, sir, do I deny to journalists talent, science, love of truth, patriotism, and what you please. They are very worthy and intelligent people, whom I undoubtedly should wish to resemble, had I the honor to know them. That of which I complain, and that which has made me a conspirator, is that instead of enlightening us, these gentlemen command us, impose upon us articles of faith, and that without demonstration or verification. When, for example, I ask why these fortifications of Paris, which in former times, under the influence of certain prejudices, and by means of a concurrence of extraordinary circumstances, supposed for the sake of the argument to have existed, may perhaps have served to protect us, but which it is doubtful whether our descendants will ever use, when I ask, I say, on what grounds they assimilate the future to a hypothetical past, they reply that M. Thiers, who has a great mind, has written upon this subject a report of admirable elegance and marvellous clearness. At this I become angry, and reply that M. Thiers does not know what he is talking about. Why, having wanted no detached forts 7 years ago, do we want them today? Oh, damn it, they say, the difference is great. The first forts were too near to us. With these we cannot be bombarded. You cannot be bombarded, but you can be blockaded, and will be if you stir. What? To obtain blockade forts from the Parisians, it has sufficed to prejudice them against bombardment forts. And they thought to outwit the government. Oh, the sovereignty of the people! Damn it! Monsieur Thiers, who is wiser than you, says that it would be absurd to suppose a government making war upon citizens, and maintaining itself by force and in spite of the will of the people. That would be absurd. Perhaps so. Such a thing has happened more than once, and may happen again. Besides, when despotism is strong, it appears almost legitimate. However that may be, they lied in 1833, and they lie again in 1841, those who threaten us with the bombshell. And then, if Monsieur Thiers is so well assured of the intentions of the government, why does he not wish the forts to be built before the circuit is extended? Why this air of suspicion of the government, unless an intrigue has been planned between the government and Monsieur Thiers? Damn it! We do not wish to be again invaded. If Paris had been fortified in 1815, Napoleon would not have been conquered. But I tell you that Napoleon was not conquered, but sold; and that if, in 1815, Paris had fortifications, it would have been with them as with the 30,000 men of Grouchy, who were misled during the battle. It is still easier to surrender forts than to lead soldiers. Would the selfish and the cowardly ever lack reasons for yielding to the enemy? But do you not see that the absolutist courts are provoked at our fortifications? A proof that they do not think as you do. You believe that, and for my part, I believe that in reality they are quite at ease about the matter, and, if they appear to tease our ministers, they do so only to give the latter an opportunity to decline. The absolutist courts are always on better terms with our constitutional monarchy than our monarchy with us. Does not Monsieur Guizot say that France needs to be defended within as well as without? Within? Against whom? Against France. O Parisians, it is but 6 months since you demanded war, and now you want only barricades. Why should the Allies fear your doctrines when you cannot even control yourselves? How could you sustain a siege when you weep over the absence of an actress? But finally, do you not understand that by the rules of modern warfare the capital of a country is always the objective point of its assailants? Suppose our army defeated on the Rhine, France invaded, and defenseless Paris falling into the hands of the enemy. It would be the death of the administrative power. Without a head it could not live. The capital taken, the nation must submit. What do you say to that? The reply is very simple. Why is society constituted in such a way that the destiny of the country depends upon the safety of the capital? Why, in case our territory be invaded and Paris besieged, cannot the legislative, executive, and military powers act outside of Paris? Why this localization of all the vital forces of France? Do not cry out upon decentralization. This hackneyed reproach would discredit only your own intelligence and sincerity. It is not a question of decentralization. It is your political fetishism which I attack. Why should the national unity be attached to a certain place, to certain functionaries, to certain bayonets? Why should the Place Maubert and the Palace of the Tuileries be the Palladium of France? End of Second Memoir, Part 6.